So your only concern here for this particular brief is with who can be affected by these federal firearms prohibitions, right, or these federal restrictions,
right?
And not how they can be affected or things
Precisely.
of that nature.
Yeah, it's that it's who can be restricted in some way on the exercise of their Second Amendment rights. That's our job for the court, is to say it's okay for the C1 people, the credible threat, to have their rights restricted. But then really the most pages in the brief go into a related doctrinal issue. And we talked about the precedents of people losing some of their right to arms based on a judicial finding of dangerous conduct.
Right.
But on top of those, the United States government, in lots of lower court cases and a lot of amici in support of the United States, in this case, in the Supreme Court,
yes,
have said, another reason that restricting Second Amendment rights is okay is look at all the precedents we have about restrictions on the right to arms from olden days, for Catholics,
right,
for poor people, for
sort of categorical,
for free bans, people of color, for slaves, and or people who wouldn't swear a loyalty oath during the American Revolution because they happened to believe in a strict interpretation of the Bible, where Jesus in Matthew chapter 5, verse 34 says, "Swear not at all." And so they would say, well, yeah, I'm a very loyal American citizen, but I ain't going to swear a loyalty oath because I will never swear anything. And what we say in the brief is all those precedents, even though the gun ban lobby loves them and cites them all the time as supposed precedents that can be used to justify modern gun control, we say, no, that's wrong, because we've enacted lots of additions to our Constitution to stop those kinds of abuses. And so when you change the Constitution or enact a new Constitution to stop abuses, then you can't today use those old abuses to justify modern gun control laws.
Right. So let's go through those quick one by one, because you guys go through these in the brief.
Yeah.
And I think a lot of them can be summed up pretty quickly. But and a lot of them are bigoted essentially. But bans on Catholics, really most of those are pre-Revolution era bans.
Yes, they England, are. There's only two of them really. So the 1689 English Bill of Rights, enacted by Parliament that year, applied in the United States because the American colonial charters said Americans have all the rights of Englishmen as if they'd been born in England. So, and all the Americans thought that they had the full set of the English Bill of Rights. The English Bill of Rights enacted in response to laws by the wicked Stuart kings, Charles I, Charles II, James II, had attempted to disarm almost the entire English population so they could be put under the tyrannical rule of these kings and their standing armies.
Right. So why don't those apply now?
Well, because the 1689 English Bill of Rights says that His Majesty's subjects, which are Protestants, have the right to arms for their defense. Mm-hmm. So in England, Protestants were about 98% of the population. So there, the English Parliament says, no, you can't go around disarming somebody just because he's a political opponent of the king. But they carved out that exception there for non-Protestants.
Sure.
So as of 1656, the French and Indian War is getting started in the United States, and Pennsylvania and Virginia enacted arms restrictions on the Catholic population there. That was consistent with the English Bill of Rights because it's Protestants only. But then in 1789, James Madison introduces the Second Amendment in the United States House of Representatives, and it eventually becomes enacted. Madison's notes in introducing it, listed what he thought were some of the defects, the weaknesses of the English Bill of Rights. And one of those was arms to Protestants. So in the Right to Arms Amendment that Madison wrote and the American people adopted, we got rid of religion as any basis for taking away somebody's arms rights. He obviously knew about the English right to arms. He could have copied it, but he chose not to. He chose not to include anything with a religious limit. And so what that means is, let's say the First Amendment free exercise of religion, that had never been enacted. But because we enacted the Right to Arms Amendment the way Madison wrote it, if somebody tried today to restrict arms rights based on religion, like let's say after 9/11, Congress had passed a bill that said American citizens who were Muslims can't have guns, that would have violated the Second Amendment directly. The Second Amendment was enacted to stop, among other things, was enacted to stop religious discrimination in arms rights.
Right. So the Bill of Rights essentially, the Second Amendment, the Bill of Rights undoes this precedent.
Exactly.
And makes it not useful for the Bruin analysis, essentially.
Precisely. Not useful for anything. It's the anti-Catholic laws are because the Second Amendment was enacted to repudiate religious restrictions. That means the old religious restrictions are examples of laws you can't have. They're negative precedents, even though, there's a lot of folks in the gun ban lobby who were saying, oh, look what they did to how they cracked down on the Catholics in Pennsylvania in 1756. That's a good precedent for us to ban arms for other groups or whatever to justify modern gun control.
Yeah, they'll argue that these were bad laws that are unconstitutional now, but should be viewed as historically relevant for modern analogs under Bruin, right?
Yeah,
you're saying it's the exact opposite is the truth.
Precisely. Once the Second Amendment's enacted by the people by ratification in 1791, that obliterates any religious discrimination in arms rights, and that's what our American constitutional right to arms became in 1791, and ever since.
Yeah.
And likewise, they'll talk about slaves.
Yeah, the next one I wanted to get into, because I think these two are kind of related, and we can talk about them at the same time. Are slaves, freed blacks, racial minorities, essentially, even post the founding, obviously, up through the Civil War, essentially. And then Native Americans or Indian tribes, where, they were both barred from having guns sold to them in most situations. And you think that the sort of the same basic framework was applied, which is the idea that neither were part of the people because they didn't view slaves as part of the people and stripped them of all their rights, essentially. And Native Americans were part of sovereign nations during that time period, right? And so once that changed, it's the same idea where these aren't things you can point back to as historical analogs that are justifiable. Right.
And so let's do the slaves first. So slavery has what are called badges and incidents, that there are auxiliary things that go along with being a slave. And as the Georgia Supreme Court said in a case in the 1850s, one of the incidents of slavery is he is not allowed to have a firearm. And so the slave states typically had laws that said slaves can't have firearms at all, or they said that they can only do it if they can only have an arm if their owner gives them written permission, or maybe they get permission from a local government official. Well, when we enacted we the people enacted the 13th Amendment to abolish slavery throughout the United States, we also, as the Supreme Court said in a very famous case called the Civil Rights Cases, we also abolished all the badges and incidents of slavery, such as disarmament. And that's why Horace Greeley, who was a very famous newspaper publisher, later was the Democratic and Liberal Republican nominee for president in 1872. He wrote that now that slavery's gone, there is absolutely no pretext for preventing the Southern blacks from having arms. And I think he was right. And that's why the gun ban lobbies are wrong to say, well, look at what Mississippi did to black people in 1850 about preventing them from having guns. That's a good that shows what the Second Amendment means. No, it doesn't, because by enacting the 13th Amendment, among the things we the people did was fortify our constitutional right to arms by obliterating a particular pretext that had been used to disarm some Americans.
Yeah.
And same thing with the 14th Amendment, which protects the privileges and immunities of all citizens of the United States, says everyone who's born in the United States, except foreign diplomats in some exceptional cases, is a citizen of the United States. You can't violate the right to due process of law. All that cumulatively means that the restrictions on free people of color, which also a lot of the southern states had, those were deliberately obliterated as well. So the fact that in North Carolina in 1845, a free black person could only have a gun if a local judge granted him a 1-year license, that's gone. That's not a precedent anymore to justify gun control in 2023.